had come up on the last day when your lordships had asked the respondent that the list of those people who were the 20 to 22 batch, that should be produced, the merit list. As per your lordships,
ideal losses, we are 40.
One after another, please, everybody don't talk.
Yes. So there are a number of applicants. I will give the particulars about all of them. And let me just introduce what my case is. And then I'll tell your lordships, my lord, how actually the whole issue can be concluded, because there are more than 2,000 vacancies. And the number of people.
And the only question which will arise, even if we assume, if we can conclude that the interpretation of the rule by the High Court is not correct, then the question of, as Mr. Gupta was saying last time, that the select list has expired. Perhaps that's it.
It's not. There are 9,000 people appointed. My learned friend was appearing, and in spite of the fact they are appointed, he was opposing relief to us. So, my lord, I am going to show the rule to your lordships today and say that even their appointment, therefore, cannot sustain.
Hold the rule in your favor.
Yes, it is.
So how can relief follow? Because in the meanwhile,
we have already been declared eligible.
2022.
We have already been declared eligible. We have already participated. Only our result is not being. Let me just give your lordships a few facts. We are people, my lord, who did this diploma, 2-year course.
We are asking you that we get the point.
Yes.
Seen.
We have participated.
Select list part of it, there is a problem.
Yes. Now even the rule. Now I'll tell your lordship. Last time my Lord Justice Mishra had said that is there a power to relax under? That's your lordship had asked. Now the rules are on the record. I'm going to show it just now. But please see the rule with me. At page 5, the rule is there. Kindly see rule 6.1 and 6.2. High Court is not right in interpreting the rule.
We agree with you. Prima facie, we agree.
Yes, the rule doesn't want.
The rule is not intended to say that you should have got the qualification by that time.
Correct.
It is intended to say that this is the qualification which should be
obtained. Correct. The NC.
When it should be, in fact, in every recruitment process.
Correct. Now see the advertisement.
By the time the interview takes place, by which time you will, because JEE and all other examinations pass through the graduation.
We had got it.
You get
now,
certificates.
Now, what is our case? We got selected in 2020 in the diploma course, 2-year course. We would have qualified by June 2022. Because the board was not in position, our training was certified to be complete in June 2022.
What she also said last time.
We can't be interpreted. I know.
It for qualification. You are on this side.
No, I'm going to tread on his toes in a bit.
Yes.
But we are a group of people,
wait.
Because have been referred to court number 2, we need to be protected. Same advertisement.
No.
What court number?
Who are the?
This has been going on for a while. They've been trying to step on everybody's toes.
Yes. Lord, I have a suggestion to make in this matter.
Tell us, because
I have a
part of it we will of course.
Your lordship may hear me. I will cover everything. And
Prima facie on rule interpretation, perhaps we are with you. We have heard them, we hear them.
So,
second question arises as to you, pursuant to the amendment in the notification, you appeared and you perhaps were.
No amendment.
What happened after that?
I'll just.
What happened after that?
Yes, only 2 minutes. We are students who got admitted in June 2020. We should have completed the diploma in June 2022. That completion of diploma means 2 years training and examination of the first year and the second year. 2 years training completion certificate is given to us on at page 147 in June 2022 itself. Since our examinations are not being held, in August 2020 we filed a writ in the High Court in 22 for a mandamus saying, please hold the examination. When the writ is pending, the first year examination is held in September. On 29th September, the result of that examination is declared. The writ comes up for hearing on 29 September. On 29 September, the High Court passes an order
Single judge passed the order.
at 217 saying that they should be also considered in this process. On 29 September itself, the board publishes the first notification. First notification specifically includes us as participating. Thus, the second notification is published on 21st October. The second notification also includes, these two notifications are there at page 219 and 222. The second notification also, yes, 219 and 221. Second notification also includes us.
Yes.
These notification, the order of the single judge is then taken up in appeal.
Division bench says that's virtually a cutoff, so you can't have it.
Yes, the division bench says you should have got it on the date of the advertisement. Now, the board does not, the board files an affidavit completely in our favor, which affidavit is reproduced by the division bench at page 12 onwards. And the board accepts at page 13. I want to read two paragraphs at page 13, para D and E. Please read those two paragraphs. The board says we are at fault.
Subsequent facts.
Yes, now subsequently what happened?